saw motherfucking design on right now. Bring it down, bring it down, bring it down. I got 3 old guys to the
Motion for summary disposition, which was held back on July 14th. Mr. Kuhn and Ms. Restraint did not appear. Ms. Kitch did appear with the zoning administrator. The court heard arguments and took testimony and issued a ruling. So as to that issue, Mr. Kuhn, why do you think that the court should give you another opportunity to argue that matter?
We weren't informed of the changed date. We were under the impression the last we knew it was August 4th was our pretrial, is what the court gave to us, and we would like the facts all to come out. Is the whole purpose of all of our efforts, and this is the most important thing in my life, considering all the harm that was unnecessarily caused at the cost of the taxpayers, and how it was just a vengeance thing by.
So I'm just talking about the hearing date.
Yeah. Yes, we would like. Michelle couldn't get time. I'm sorry, off from work. She's working through a temp service at a factory, and she fears losing her job again.
Sir,
so she couldn't take the time off for this.
I'm talking about July 14th.
Right. We didn't.
Okay.
We had no clue.
Well, you did.
I would have been there.
You did have a clue because you did file an answer to the motion for summary disposition. And the court received that.
Yeah, we
got. Hang on.
Okay.
I'll give you a chance. Just let me talk. And with that motion for summary disposition, there was a notice of hearing. So you got the motion. Because you got their motion, you got the notice of hearing. Whether you understood what the notice of hearing was for, that's another story. But the indication is that you did, in fact, receive the notice of hearing. Now, there was also, in the defendant's response to your motion to reschedule, they indicate that Ms. Restraint called shortly after the hearing and then acknowledged that the notice of hearing was actually in the packet of information that you received. Did you see that?
We received a letter of victory from them, and prior to that, it was a 54-page. I had other people read it over, and they just said that it's like taking candy from a baby, and that's how they do it. And we weren't. Trust me, if I would have known of any sort of hearing or anything in this case, that I would have walked here if I had to. And I would have started the night before, because like I said, this is the most important thing in my life. And like I said, we just wanted it to be heard. And as far as we knew, the next hearing was scheduled for August 4th. Now, moving that ahead 2 weeks and not letting us be aware of it, a 54-page packet came, and we read that all the way through. Someone else even read it through and just said it was jargon of some sort. Just the same thing that trying to get out of wrongdoing.
Okay. Right. So let me turn that over to Ms. Kitch.
Mm-hmm.
Your Honor, I think we set forth our position. I think this is unfortunate that it does show why attorneys are needed. I would argue, though, that the plain language notice of hearing with the date spelled out in the notice of hearing, which is part of the packet, is very clear, I think, even to a lay person. But I don't understand the mixing up of a pretrial and a notice of hearing for a motion for summary disposition. But giving every benefit, the bottom line is that this is why you need an attorney. And I don't think the township, I don't think that there's any good cause shown for allowing this to be regurgitated again and redone again. As you know, my client was here. So it's unfortunate that Mr. Kuhn and Michelle Restraint apparently didn't understand, but I think it was very clear.
All right, so the court is going to deny the plaintiff's motion to reschedule, or basically for reconsideration of the motion. The court is satisfied that they received a copy of the motion for summary disposition. In that, there was an original proof of service indicating that the notice of hearing for that was included in that paperwork. The plaintiffs filed a response to that motion, which tells me that yes, they did get that the motion with the notice of hearing. In addition to that, in response to the motion to reschedule, there is another affidavit that was provided by Tanya Brooks, who is a paralegal with defendants law firm, where it lays out that there was a call with Ms. Restraint on July 25th with a male individual in the background, and where they essentially acknowledged that they got the 58-page document. The notice of hearing was on the 3rd page, relayed the information to the gentleman in the background, said, okay, thank you, and said goodbye. In that packet was the information. Now, it's unfortunate, Mr. Kuhn, that that you didn't understand what the notice of hearing meant or what it required.
That call was made from here.
I'm talking now. I
While
gave you your
we were filing.
opportunity. I gave you your opportunity.
I'm sorry.
So, I think most people without a law degree are certainly would benefit from the use of an attorney. I don't think one it certainly was not required, but you have to have the knowledge of the procedures, and what you're going to represent yourself. You need to follow the same rules as anybody else, and you have to educate yourself on what things mean. So, so the court is denying the request for a rehearing.
Third time, say that.
I'm denying your request.
Yeah, I don't understand, since it was obviously just a trick.
Sir, I'm asking you to stop talking. So I'm denying the motion to rehear the issue. Now, the court did not just grant the motion for summary disposition because you weren't here. The court looked at their motion. The court looked at your response. The court read the complaint that was filed by you and Ms. Restraint. The court had, and I just didn't take their word for it. I put the zoning administrator under oath and asked him questions.
He obviously lied earlier about his statement on the facts. And I would like that to be brought into evidence as well, as far as him manipulating from the start about some stuff in the yard to taking everything I own, except for some musical instruments, furniture, and clothing. I mean, that was my life that was out there. And my grandfather's tools, all my dad's tools, all of my tools that I'm a shock pumped. I'm not familiar with their terminology on things, but if you know what a shock pump is, then you would know that my life has been dedicated to being right or wrong. And it's always been my choice to be right about things, and then to be bulldozed, run over, and flattened, stabbed in the back, and run over by somebody, and then everyone to say that's fine. Is happened to me 3 times. Once when I lost my land in East Tampa by the most wealthiest 2 people there, just without one word of defense. Now, Mr. Kuhn, it don't belong to you no more. Now it belongs to my friends. There's nothing you can do about it. Now, and then I lost my child from the same thing. The taxpayers' money funded them, and my wife paid for an attorney. My mother paid for an attorney that did nothing in our behalf because it was already done deal behind the curtains, let's say, because there was nothing wrong with our relationship with my daughter and my wife and me. And that was the second time that we basically had no defense at all because it was already settled by hundreds of thousands of dollars put into the effort against us, and we're left with nothing. And now this time, it seems that they've done the same thing that my stepdad did before when he damaged his car and then tried to blame me, took me to court or filed a suit and kept the trial from me. So I didn't have a clue that he was, so he went to court. I wasn't there because I didn't know of it, and he won. And that was when I was in my 20s. And now the very same thing again. I don't know how they done it. And just, it appears to get a victory when it was him trying to tell me where I could be and when I could be on my private property that it was my dad's. I mean, I had a safe haven all my life that I could store my rare materials and some of my tools. And then when my wife moved it, or my ex-wife, we had to be divorced to try to get her daughter back, which was unsuccessful, like everything that has been paid for by people utilized by a select few to totally manipulate right from wrong and get a victory. And $54,000 worth of my materials that went into a dumpster and to Jerry's towing, a $4,000 bike, my best toy that I ever just got, ever in my life, because my wife sold her house, ex-wife sold her house, and they got $750 for it. Now, the rest of the $54,000, and which is a modest amount, considering that some of this stuff was priceless, belonged to my grandfather, who helped my dad get the place. Just like my dad helped me get after he passed away. I mean, it was vacant for 9 years that I just used it to keep my stuff there. Basically, while my dad was in a nursing home and living with my mom. But anyways, Michelle and I are good people, honest people, and the rest of my family went into clergy, which I considered because I had the heart for it and the patience, and instead a shop pump. That was my occupation. And it's French for framing carpenter. So, and I tried desperately and have still tried, considering that they wanted $5,000 from the towing company just to get, they wouldn't tell me because they were 100% incooperative.
We're getting on.
I couldn't get an attorney. I still can't get an attorney.
Please stop.
I'm sorry.
Please stop.
Pathetic. I'm sorry to say.
Stop.
But right is right.
Please stop.
Wrong is wrong.
So I put the zoning administrator under oath. We went over the items. If you interrupt me again, I'm going to hold you contempt of court. Okay? I give you an opportunity to talk, and I'll let you know when it's your turn. But please don't interrupt me again. He testified that they took the items that were on the list. So what we have here, sir, is an order from another court that was fully litigated as to do it, as to what needed to be removed, under what timeframes, and what would happen if it didn't occur. Okay, so that's not my order. That's a different court's order. They were enforcing an order that was made by another court. Now, you could disagree with that all day long, but that was the court's order. And the court found, the other court, district court, found that you did not comply with this order. They held you, stop, they held you in contempt of court for not doing that.
We did comply. I was crippled and complied. Sorry. 100%. Sorry.
So that court found that you did not comply.
Because he lied.
No, that
Done deal?
court's order was. Now, we have, the other issue that we have today is the township's request for attorney's fees.
Take my land, because that's what he was after in the first place. When he ordered us to vacate the property, and 35 calls to my wife to vacate the property. We're squatters. We had no right to be there. And we complied. There was nothing in that yard but 2 sheds, and the court said that we could have 3 recreational vehicles. So we had a Jeep and a sailboat and a utility trailer that had boats on it under a tarp. That was the 3. The judge said that I could have that. And the sheds, just like everybody else inside of a shed, no more problem, except for he wanted a victory. And look, he obviously won, right? You just said that you just won.
So the issue before the court, the other issues are the attorney's fees. So I think that a partial award is appropriate. The courts reviewed the documentation regarding attorney's fees from January 1, 2025 through August 1, 2025. So the court is awarding $13,552.48. Now, as to the cost to Jerry's Towings and the dumpsters and stuff like that, that's not under this court's jurisdiction. That would be imposed or assessed in the court that ordered those things. So that would go back to the district court as to whether the costs that were incurred by cleaning up the property are appropriate and just. So that's not the issue before this court. So the court is awarding $13,552.48 in attorney's fees, because that's distributed just in this case. And the rest of if they want the other money, they have to go to district court, Judge State, and see what he says about that. So that's all for today.